conflict of laws. Applicable laws, laws governing contracts. The validity of the contract will be governed by law, because the validity refers to the element of the making of the contract in this case. Unless the parties agreed to be bound by another law, the performance will be governed by the law of the Philippines where the contract is to be performed. The consideration will be governed by the law of the United States where the ranch is located. Optional addendum: in the foregoing cases when the foreign law would apply, the absence of proof of that foreign law would render Philippine law applicable under the eclectic theory. Applicable laws, Article 15, 16 and 17. Capacity to contract marriage is governed by Philippine law. The Family Code pursuant to Article 15, Civil Code, which provides that our laws relating to, among others, legal capacity of persons are binding upon citizens of the Philippines even though living abroad. By way of exception to the general rule of lex recipe prescribed by the first paragraph of Article 16, Civil Code, a person's successional rights are governed by the national law of the decedent, second part. 16. Successional rights are governed by Philippine law pursuant to Article 1039 and the second paragraph of Article 16, both of the Civil Code. Article 1039, Civil Code, provides that capacity to succeed shall be governed by the law of the nation, of the decedent. National law. Article 16 provides in paragraph 2 that the amount of successional rights, order of succession, and intrinsic validity of testamentary succession shall be governed by the national law of the decedent. The extrinsic validity of the will is governed by law, it being the law where the will was made. 4. Philippine law, by implication from the provisions of Article 816, Civil Code, which allows even an alien who is abroad to make a will in conformity with our Civil Code. The intrinsic validity of his will is governed by Philippine law, it being his national law. Aliens may obtain divorces abroad which may be recognized in the Philippines provided that they are valid according to their national law. The foreigner who executes his will in the Philippines may observe the formalities described in 1. The law of the country of which he is a citizen under Article 817 of the new Civil Code, or 2. The law of the Philippines being the law of the place of execution under Article 17 of the new Civil Code. Article 16 of the new Civil Code provides that intrinsic validity of testamentary provisions shall be governed by the national law of the person whose succession is under consideration. Article 17 of the Civil Code provides that the forms and solemnities of contracts, wills and other public instruments shall be governed by the laws of the country in which they are executed. Example: the contract of employment was executed in Manila, Philippine law should govern. Applicable laws, capacity to buy land. Philippine law governs the capacity of the Filipino to buy the land. In addition to the principle of lex recipe given above, Article 15 of the NCC specifically provides that Philippine laws relating to legal capacity of persons are binding upon citizens of the Philippines no matter where they are. Japanese law governs the capacity of the Japanese to sell the land, being his personal law on the basis of an interpretation of art. 15. NCC. While as a general rule capacity of persons is governed by the law of his nationality, capacity concerning transactions involving property is an exception. Under Article 16 of the NCC, the capacity of persons in transactions involving title to property is governed by the law of the country where the property is situated. Since the property is in the Philippines, Philippine law governs the capacity of the seller. Applicable laws, contracts contrary to public policy. A contract is the law between the parties, but the law can disregard a contract if it is contrary to public policy. The provisions of the 1987 Constitution on the Protection of Labor and on Social Justice, Sec. 10, Part 2, embody a public policy of the Philippines. Article 17 provides that are prohibitive laws concerning persons, their acts, or their property or which have for their object public order, public policy and good customs shall not be rendered ineffective by laws or conventions agreed upon in a foreign country. Doctrine of processual presumption. A foreign law is deemed similar or identical to Philippine law in the absence of proof to the contrary. Applicable laws, contracts of carriage, can recover damages under Philippine law for breach of contract of carriage. Philippine law should govern is the law of the place where the plane tickets were bought and the contracted carriage was executed. Supreme Court applied Philippine law in recovery of damages for breach of contract of carriage for the reason that it is the law of the place where the contract was executed. Applicable laws, labor contracts. Labor legislations are generally intended as expressions of public policy on employer-employee relations, only to the extent that its provisions are not inconsistent with Philippine labor laws intended particularly to protect employees. The third paragraph of Article 17 of the Civil Code provides that prohibitive laws concerning persons, their acts or property, and those which have for their object public order, public policy and good customs shall not be rendered ineffective by laws or judgments promulgated, or by determinations or conventions agreed upon in a foreign country. Article 1700. The relations between capital and labor are not merely contractual. They are so impressed with public interest that labor contracts must yield to the common good. Therefore, such contracts are subject to the special laws on labor unions, collective bargaining, strikes and lockouts, closed shop, wages, working conditions, hours of labor and similar subjects. Applicable laws, laws governing marriages. The marriage of Monson Johnson was valid when celebrated because all marriages solemnized outside the Philippines, Tokyo, in accordance with the laws in force in the country where they are solemnized, Japan, and valid there as such, are also valid in the Philippines. Applicable laws, sale of real property. Article 17 of the Civil Code provides that the forms and solemnities of contracts, wills, and other public instruments shall be governed by the laws of the country in which they are executed. Applicable laws, succession, intestate and testamentary. Article 16 of the new Civil Code provides that intestate and testamentary succession shall be governed by the national law of the person whose succession is under consideration. Applicable laws, succession of aliens. The national law of the decedent, French law, shall govern in determining who will succeed to his estate. The legal basis is Article 16 par. 2. NCC. The distribution of the real properties in the Philippines shall be governed by French law. The legal basis is Article 16, NCC. The distribution of the personal properties in Germany shall be governed by French law. The legal basis is Art. 16, NCC. Applicable laws, wills executed abroad. Under Articles 815 and 17 of the Civil Code, the formality of the execution of a will is governed by the law of the place of execution. Definition, COGNOVIT, borrowing statute, characterization. COGNOVIT is a confession of judgment whereby a portion of the complaint is confessed by the defendant who denies the rest thereof. COGNOVIT is a statement of confession. Oftentimes, it is referred to as a power of attorney, or simply as a power. It is the written authority of the debtor and his direction to the clerk of the district court or justice of the peace to enter judgment against the debtor as stated therein. COGNOVIT is a plea in an action which acknowledges that the defendant did undertake and promise as the plaintiff in its declaration has alleged, and that it cannot deny that it owes and unjustly detains from the plaintiff the sum claimed by him in his declaration, and consents that judgment be entered against the defendant for a certain sum. COGNOVIT is a note authorizing a lawyer for confession of judgment by defendant. Borrowing statute, laws of the state or jurisdiction used by another state in deciding conflicts, question involved in the choice of law. Characterization is otherwise called classification or qualification. It is the process of assigning a disputed question to its correct legal category. Characterization is a process in determining under what category a certain set of facts or rules fall. Definition, forum nonconvenience, long-arm statute. Forum nonconvenience is a principle in private international law that, where the ends of justice strongly indicate that the controversy may be more suitably tried elsewhere, then jurisdiction should be declined and the parties relegated to relief to be sought in another forum. Where in a broad sense the ends of justice strongly indicate that the controversy may be more suitably tried elsewhere, then jurisdiction should be declined and the parties relegated to relief to be sought in another forum. Forum nonconvenience means simply that a court may resist imposition upon its jurisdiction even when jurisdiction is authorized by the letter of a general venue statute. Forum nonconvenience is a doctrine whereby a court of law having full jurisdiction over a case brought in a proper venue or district declines to determine the case on its merits because justice would be better served by the trial over the case in another jurisdiction. Long-arm statute is a legislative act which provides for personal jurisdiction via substituted service or process over persons or corporations which are not residents of the state and which voluntarily go into the state directly or by agent or communicate with persons in the state for limited purposes. In actions which concern claims relating to performance or execution of those purposes. Long-arm statute refers simply to authorized substituted service. Divorce, effective divorce granted to former Filipinos. Renvoy doctrine. Renvoy, which means referring back, second marriage will be governed by Philippine law under the principle of lex loci celebrationis. Domiciliary theory versus nationality theory. Domiciliary theory posits that the personal status and rights of a person are governed by the law of his domicile or the place of his habitual residence. The nationality theory, on the other hand, postulates that it is the law of the person's nationality that governs such status and rights. Forum nonconvenience and lex loci contractus. Lex loci contractus may be understood in two senses, as follows. 1. It is the law of the place where contracts, wills, and other public instruments are executed and governs their forms and solemnities pursuant to the first paragraph. Article 17 of the New Civil Code, or 2. It is the proper law of the contract. The system of law intended to govern the entire contract, including its essential requisites. Indicating the law of the place with which the contract has its closest connection, or it is the law of the place where the airline ticket was issued, where the passengers are nationals and residents of, and where the defendant airline company maintained its office. Forum non-convenience means that a court has discretionary authority to decline jurisdiction over a cause of action when it is of the view that the action may be justly and effectively adjudicated elsewhere. Case: the Philippine courts cannot acquire jurisdiction over the case of Felipe. Firstly, under the rule of forum nonconvenience, the Philippine court is not a convenient forum as all the incidents of the case occurred outside the Philippines. Neither are both coals and energy doing business inside the Philippines. Secondly, the contracts were not perfected in the Philippines. Under the principle of lex loci contractus, the law of the place where the contract is made shall apply. Lastly, the Philippine court has no power to determine the facts surrounding the execution of said contracts. And even if a proper decision could be reached, such would have no binding effect on coals and energy as the court was not able to acquire jurisdiction over the said corporations. Manila Hotel Corp. v. NLRC 343 SCRA 1, 13 Not 14, 2000. Nationality theory. Being foreigners, HK, their status, conditions and legal capacity in the Philippines are governed by the law of Hong Kong, the country of which they are citizens. Since their marriage is valid under Hong Kong law, it shall be valid and respected in the Philippines. Naturalization. The marriage of an alien woman to a Filipino does not automatically make her a Filipino citizen. She must first prove in an appropriate proceeding that she does not have any disqualification for Philippine citizenship. Yangon Chu v. Republic of the Philippines 158 SCRA 593, 1988. Theory. Significant relationships theory. Significant relationships theory. There are contacts significant to the Philippines. Among these are that the place of business is the Philippines, the employee concerned is a Filipino and the suit was filed in the Philippines, thereby justifying the application of Philippine law. In the American Airlines case, the court held that when what is involved is paramount state interest such as the protection of the rights of Filipino laborers, the court can disregard choice of forum and choice of law. Therefore, the Philippine court should not apply the stipulation in question. Torts prescriptive period. Case: the U.S. court will apply U.S. law, the law of the jurum, in determining the applicable prescriptive period. While U.S. law is silent on this matter, the U.S. court will not apply Philippine law in determining the prescriptive period. It is generally affirmed as a principle in private international law that procedural law is one of the exceptions to the application of foreign law by the forum. Since prescription is a matter of procedural law even in Philippine jurisprudence, Code Alton v. POEA, JVLRC, Rowam and Root International 238 SCRA 721, 1994. The U.S. court will apply either high or federal law in determining the applicable prescriptive period and not Philippine law. The restatement of American law affirms this principle. Adoption. Adoption, use of surname of her natural mother. An illegitimate child, upon adoption by her natural father, can use the surname of her natural mother as her middle name. The court has ruled that there is no law prohibiting an illegitimate child adopted by her natural father to use, as middle name, her mother's surname. What is not prohibited is allowed. After all, the use of the maternal name as the middle name is in accord with Filipino culture and customs, and adoption is intended for the benefit of the adopted. Intercountry adoption formalities. Republic Act No. 8043 or the Intercountry Adoption Act, allows aliens or Filipinos permanently residing abroad to apply for intercountry adoption of a Filipino child. The law, however, requires that only legally free child, or one who has been voluntarily or involuntarily committed to the DSWD or any of its accredited agencies, may be subject of inter-country adoption. The law further requires that aside from possessing all the qualifications, the adoptive parents must come from a country where the Philippines has diplomatic relations, and that the government maintains a similarly accredited agency, and that adoption is allowed under the national law of the alien. Moreover, it must be further shown that all possibilities for a domestic adoption have been exhausted, and the intercountry adoption is best for the interest of the child. Parental authority. Rescission of adoption. The natural mother, Carol, should have the better right in light of the principle that the child's welfare is the paramount consideration in custody rights. Qualification of adopter. Under paragraph 3, article 184 of the Family Code, an alien, as a general rule, cannot adopt. However, an alien who is a former Filipino citizen and who seeks to adopt a relative by consanguinity is qualified to adopt, par. 3. Art. 184 Family Code. Paragraph 3 of Article 184 of the Family Code does not make any distinction. The provision states that an alien who is a former Filipino citizen is qualified to adopt a relative by consanguinity. Under Sec. 7b, Art. 3 of the new Domestic Adoption Act, an alien who possesses all the qualifications of a Filipino national who is qualified to adopt may already adopt, provided that his country has diplomatic relations with the Philippines, that he has been living in the Philippines for at least three continuous years prior to the filing of the application for adoption, and maintains such residence until the adoption decree is entered, that he has been certified by his diplomatic or consular office or any appropriate government agency that he has the legal capacity to adopt in his country, and that his government allows the adoptee to enter his country as his adopted child. Qualification of adopter. Applicable law. The law that should govern the action is the law in force at the time of filing of the petition. At that time, it was the Child and Youth Welfare Code that was in effect, not the Family Code. Petitioners have already acquired a vested right on their qualification to adopt, which cannot be taken away by the Family Code. Republic v. Miller Gr. No. 125932, April 21, 1999, citing Republic v. Court of Appeals 205 SCRA 356. Qualifications of adopter. Rules on adoption effective August 22, 2002 provides the following: SEC 4. Who may adopt? The following may adopt: any Filipino citizen of legal age, in possession of full civil capacity and legal rights, of good moral character, has not been convicted of any crime involving moral turpitude, who is emotionally and psychologically capable of caring for children, at least 16 years older than the adoptee, and who is in a position to support and care for his children in keeping with the means of the family. The requirement of a 16-year difference between the age of the adopter and adoptee may be waived when the adopter is the biological parent of the adoptee or is the spouse of the adoptee's parent. Any alien possessing the same qualifications as above stated for Filipino nationals, provided: A. That his country has diplomatic relations with the Republic of the Philippines. B. That he has been living in the Philippines for at least three continuous years prior to the filing of the petition for adoption and maintains such residence until the adoption decree is entered. C. That he has been certified by his diplomatic or consular office or any appropriate government agency to have the legal capacity to adopt in his country. D. And that his government allows the adoptee to enter his country as his adopted child. Provided, further, that the requirements on residency and certification of the alien's qualification to adopt in his country may be waived for the following. A former Filipino citizen who seeks to adopt a relative within the fourth degree of consanguinity or affinity, or B. One who seeks to adopt the legitimate child of his Filipino spouse. Or C. One who is married to a Filipino citizen and seeks to adopt jointly with his spouse a relative within the fourth degree of consanguinity or affinity of the Filipino spouse. Successional rights of adopted child. Case: the succession to the estate of B.M. Jr. is governed by Philippine law because he was a Filipino when he died. Article 16, Civil Code. Under Article 1039 of the Civil Code, the capacity of the heir to succeed is governed by the national law of the decedent and not by the national law of the heir. Hence, whether or not YV can inherit from BM Jr. is determined by Philippine law. Under Philippine law, the adopted inherits from the adopter as a legitimate child of the adopter. YV, however, cannot inherit, in his own right, from the father of the adopter, BM Sr., because he is not a legal heir of BM Sr. The legal fiction of adoption exists only between the adopted and the adopter. Teotico v. Del Val 13 SCRA 406, 1965. Neither may he inherit from BM Sr. by representing BM Jr. because in representation, the representative must be a legal heir not only of the person he is representing but also of the decedent from whom the represented was supposed to inherit. Article 973, Civil Code.